My name is Gary MacInnis. I'm a lawyer in Austin, Texas. There is a statute of limitations on wills in the state of Texas. A will must be probated within 4 years after the death of the testator. After 4 years, the court has discretion to allow the admission of a will to probate as a muniment of title, but there will be no letters of testamentary and there will be no administration of the estate. The primary purpose of that order admitting will to probate as a muniment of title will be to convey title to the real estate. The probate court judges inclined to allow the admission of the will after the 4 years as a muniment of title if the proponent of the will is not at fault for the delay and if there's a defect in the chain of title, which defect will be repaired by this will admitted to probate as a muniment of title. If the 4 years expire without having the will admitted to probate, there is some complications. One, you have to serve all the heirs at law of the deceased, not just the beneficiaries named in the will. That's not a problem if the beneficiaries in the will and the heirs at law are the same. But if the heirs at law are different than the beneficiaries, they're more inclined to object to the proceeding. They will receive a citation and a copy of the will and your copy of your petition, and they will come to understand at some point that if they object to this will, that the property is going to be inherited by them and the other heirs. If the will is not admitted to probate, the property will pass to the heirs of the deceased in the same way as if he had died intestate.